Hello, my name is Kathleen Overton, and I am an attorney at Path's Law Firm. We are a boutique law firm focusing on estate planning, elder law, probate, and trust administration. Now, there are a lot of things that I love about being an estate planner, but one of my favorite things is that it's one of the few areas of law where clients come to us before they have a problem. Of course, we get our fair share of clients who are in a crisis, and we are always happy to help them as well. But I love being able to work with clients to help get their estate in a place where they can avoid some of those problems that we often see. We can help them minimize taxes, protect their assets, and make sure that their family gets along after they're gone. Now, there are 5 mistakes that I often see seniors make. One of the biggest mistakes is that they have a power of attorney document, but that document doesn't address all of the elder law needs. When we are planning an estate for an elderly client who maybe has lost capacity, we do so through that power of attorney document. And we need to make sure that that document has all of the powers in it that we need to use. Important powers are the ability to gift and the ability to set up a trust, among others. So anytime that I review a power of attorney document, I look for those things. The second mistake that I often see is that clients forget to fund their trust. So maybe they've gone to an attorney and created a trust, but they never retitled any of their assets to the name of the trust. I always tell clients to think of a trust like a box. After we have signed the trust document, we have built the box, but that box doesn't do anything until we put our assets into that box. And there is a process we have to go through to do that. Without doing that, you're stuck at the same position you were before you ever created the trust and will likely have to go through probate. The third mistake that I see seniors make is that they don't know where all of their assets are. Anytime I work with a senior to plan their estate, I make sure that we have uncovered all of the assets and that all of them are appropriately titled or have the appropriate beneficiary designation. Without doing so, it makes it very difficult for your power of attorney, for your trustee, or for your personal representative to come in and start managing your estate. The fourth mistake that I often see seniors make is that they add their adult child as a co-owner on their bank account or savings account or brokerage account. And I know that they do so in order for the adult child to have access to that account when needed and to inherit that account upon the death of the senior. What they don't often realize is that by doing so, they open up that asset to all the creditors of the child. So if the child is out driving and gets in a car wreck and gets sued, that judgment can now come against mom and dad's assets. Most people do not want that to happen. Now, the fifth mistake that I often see seniors make is that they set up a trust years ago and they never come back and revisit the plan. A lot of times beneficiaries change, fiduciaries change, and just circumstances change. We recommend that we review an estate plan every 3 to 5 years. As you progress, there are different estate planning techniques that might work for you and might be necessary to protect your assets. Now, at Pat's Law Firm, we're happy to help with all of these different areas. So come in for a consultation and we can talk about what works best for you and for your estate. Thank you.